Are you ready? Can we ask the expert to come, please? Good afternoon and welcome. Can you please, for the record, state your full name?
Microphone, please.
Yeah, turn it. No, you have to turn your microphone on. There you go.
Todd Allen Flubacher.
Thank you. You have a declaration in front of you.
Yes. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you very much. We give the floor to respondent for direct.
Thank you, Mr. President. We have no direct. Mr. Flubacher will proceed directly to his presentation. Thank you.
Okay, so you have the floor for the next 30 minutes. The secretary will alert you when you have 5 minutes left.
Okay.
So please go ahead.
Thank you. Thank you very much for having me this afternoon. I would note this is my first time testifying as an expert witness in a matter like this. I have served as an expert witness in other matters. They've all settled, and I haven't presented before a tribunal like this before, so just thought I would mention that as I start. First, excuse me. I note that while my report was based solely on the title page and the table of contents and pages 1, 2, 31, 32, and 34 of the trust agreements, because those were the only pages that were made available to me at the time of my report, I have now had the opportunity to review the entirety of the 2 trust agreements because they were attached as exhibits to Mr. Olson's expert report, and my testimony here today is based upon my review of the entire trust agreements. So to begin, I just wanted to sort of give a little background on the structure of these trusts and the reasons for the way these trusts are structured as revocable amendable trusts with an investment committee, a protector committee that have certain powers over the trust, and the grantor's power to revoke and amend the trust agreements. When a non-U.S. person sets up a trust, particularly if they set up a trust in the U.S. for U.S. persons who are going to be beneficiaries of the trust, it's very, very common to create a trust that is a foreign revocable trust. A trust that's created by a non-U.S. person could be created as a foreign trust or a U.S. trust, and a non-grantor trust or a grantor trust. Taking first the grantor trust, non-grantor trust distinction. When U.S. persons set up trusts, they can create a grantor trust and it's treated as being totally disregarded for income tax purposes, and they are treated as the owners for tax purposes of all of the income. And there are a number of ways that you can do that. For a non-U.S. person, it's a different set of rules, and there are only 2 ways that you can do that. The trust either has to be fully revocable and amendable, and or the grantor has to be the sole beneficiary during the grantor's lifetime. And there are a number of reasons why a non-U.S. person would set up a trust that is a foreign grantor trust, because there are negative tax consequences if the trust is treated as a non-grantor trust, and i.e. a separate taxpayer. There are very complicated tax rules around that, but in particular, accumulations of income could be clawed back and taxed as distributions to U.S. persons in the future. And so these trusts are very commonly structured as fully revocable and amendable trusts by the grantor. Additionally, it is preferable during the grantor's lifetime, when the trust holds non-U.S. assets, for the trust to be treated as a foreign trust rather than a U.S. trust. And the ways that you can do that is by retaining certain rights over the trust, like the ability to remove and replace the trustee, direct investments, direct distributions. Those are things that we call controlling substantial decisions that causes a trust to be a foreign trust. So there are hundreds, perhaps thousands of trusts that are in Delaware, and many trusts that I have reviewed that are structured as foreign grantor trusts in exactly this kind of scenario. So it's very common. But clearly they are they are trusts, and it's a wealth planning structure that is frequently used and is advisable for clients in this type of situation. Now, Mr. Olson's report, he noted that these trusts are more akin to just mere will substitutes or agency relationships, and they're not really trusts. And I believe that opinion is incorrect. The seminal case in Delaware, the Lewis against Hansen case, which went to the Delaware Supreme Court and ultimately went to the U.S. Supreme Court, which held in favor of the Delaware Supreme Court because there were competing opinions between the Florida Supreme Court in that case and the Delaware Supreme Court, held that a trust in substantially similar circumstances that was revocable, it was a directed trust, it was a very similar trust structure. It was argued that that was a mere will substitute, and the court rejected that conclusion. And I'm unaware of any Delaware case that has held that a trust is a mere will substitute or an agency relationship. And Lewis against Hansen is the seminal case, and it's still good law. When I review a trust to sort of ascertain whether the trust is a valid and existing trust, you start by looking at a couple of the factors that are necessary in order to create a trust. Does the grantor express intent to create a trust in the document, which we do have here in these trust agreements? Did the grantor deliver the initial trust res, R-E-S, which is a Latin word that means the subject of the trust, a trust asset to the trustee? Without holding a trust asset, you don't have a valid trust until you have an asset that's the subject of the trust. The trustee has to accept the trust assets in its fiduciary capacity as trustee and accept the role of trustee. And Commonwealth did that here, and it's evidenced in the document. And Commonwealth holds legal title to the assets, at least the assets that I was able to review documents that support. The legal title is held by Commonwealth Trust Company in its capacity as trustee. So that was how legal title was held. In an agency relationship, incidentally, the agent does not take legal title to assets in its name. It's acting on behalf of the principal. In addition, these trust agreements contain numerous provisions that evidence an intent to create a valid trust. Commonwealth acknowledged receipt of the assets and holds them in trust, and there are a whole number of other provisions, which I've listed some of them here on this slide, that demonstrate an intent to create a trust, like the addressing the applicability of the rule against perpetuities, which applies to trusts, that the trusts should be characterized as trusts for tax purposes, that the trustee compensation is fiduciary compensation as a trustee, and importantly, paragraph L of Article 3, which grants a list of exclusive duties to the trustee in Delaware, and there's a list of 8 duties that are sort of in small Roman numeralettes, which are administrative, discretionary responsibilities of the Delaware trustee that it holds solely and exclusively as trustee. Interestingly, that list of duties and that provision, that administrative trustee provision, was a provision that was developed by our firm some 25 years ago to adopt the principles that are in the Lewis against Hansen case to demonstrate that a trust is a valid and existing trust because it has assigned exclusive fiduciary responsibilities to a trustee in Delaware, and that the validity of the trust is governed by Delaware law. I also note, and I didn't capture that provision when I had only seen the table of contents as a part of the pages that I had reviewed, because paragraph L of Article 3 is actually not in the table of contents. I can only make assumptions as to why that may be, but it may be that late in the drafting stages, someone recognized, okay, we're going to put this trust in Delaware. Frequently, that type of provision is added, often as a request from the trustee to ensure that it has administrative situs in Delaware and it has those sole responsibilities and that Delaware law governs. But maybe somebody didn't update the table of contents, I don't know, but that is an important provision. And notably, there's not a single provision in the document that identifies this as an agency relationship or the intention to do anything other than to create a trust.
I lost the English transcript. I think we all lost the English transcript. I'm just seeing the Spanish version. Yeah.
It says session invalid.
Is it everybody's? Yes.
Yeah. The follow button.
And then go back to Safari, it'll come up. Connect room one. Yep, we'll put two, 1, 2, 3, 4. Yeah, now this is up and running. You want to close these out just a little bit. Okay. Room one, info day two, passwords 1, 2, 3, 4.
Like this. And then go to
Room one. You're up? You're up here? Excellent. Sounds up and running? Oh, thank you so much. This is where we're at.
I'll feel down.
So if you double click on the, yeah.
We
double
did
click
the,
it. This is off the screen. This would be right, right? Okay, two, password 1, 2, 3, 4. Here you go.
Okay, go ahead.
Thank you. I also, I believe it's my view that Mark Olson's statement that the trusts will be asset protection trusts following the death of the grantor is incorrect. By definition, an asset protection trust is a trust that is structured under the Qualified Dispositions and Trust Act under Delaware law to protect the assets of the trust from the claims of the grantor's creditors during the creditor's lifetime. The purpose of the statute is to override the common law rule that provides that if an individual creates a trust for their own benefit, whether it's irrevocable by its terms, whether it says it has a spendthrift clause that applies to the grantor, nevertheless, the grantor's creditors are able to get access to all the assets of the trust that the grantor created for his or her own benefit. And if a trust is designed to qualify and meet the requirements of the Qualified Dispositions and Trust Act, then it's entitled to creditor protection during the grantor's lifetime. And there are some requirements for doing that, including the trust has to be irrevocable from its inception during the lifetime of the grantor. The grantor cannot possess the power to control any distributions, and the trust agreement has to contain a specific spendthrift clause that's found in the statute and that applies to the grantor. So by definition, saying that the trust is an asset protection trust following the death of the grantor doesn't really make any sense in terms of what an asset protection trust is, and I disagree with that conclusion.
Thank you so much. Claimant, you have the floor.
Thank you, Mr. President, and good afternoon, Mr. Flubacher. I want to first of all confirm that you have a clean copy of your report in front of you,
I do.
and I'd also like to confirm that you have a copy of Mr. Olson's exhibits. I believe they're to your left. And you could take a
It
second
appears
to
I
skim
do.
through. Sorry, to confirm they're right there.
Yes, it appears so.
Mr. Flubacher, are you also able to see the screen in front of you?
It's not showing anything right
Okay,
now. but
well,
yeah.
when it shows something, I'll ask to confirm as well. Now, to begin, you were retained by Greenberg Traurig as an expert in Delaware trust law, correct?
Correct.
And when were you first retained by Greenberg Traurig?
I don't recall the exact date. I know my report is dated January, so it would have been sometime a few weeks prior to that, but I apologize, I don't recall the exact date of my retention.
So would approximately December sound about right?
That could be correct.
Okay. Now, Mr. Flubacher, I want to walk...
Yes.
Thank you, Mr. Flubacher. No further questions, Mr. President.
Respondent?
Just very briefly, Mr. President, if I may, can we, Ryan, please put the last slide of Mr. Flubacher presentation? Please.
Well, your first experience was short and not painful, so we thank you very much for your patience and cooperation. You're now free to go. The tribunal does not have questions either. Thank you so much.
All right, thank you.
So we move on to the next expert.
We're ready, Mr. President.
Mr. Olson, good afternoon. You have heard the routine, so I would ask you to first confirm your name for the record.
Mr. President, my name is Mark Olson.
Thank you so much. Can you read the declaration that you have in front of you?
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you very much. Claimant, you have the floor.
Thank you, Mr. President. Mr. Olson, first of all, good afternoon.
Good afternoon.
Were you here for Mr. Mander's testimony this morning? This is Mr. Henry Mander, the expert of Cayman Islands law.
Yes.
Do you recall when Miss Vance asked him about the relevance of the settlor's oral testimony to the construction of a trust under the law of the Cayman Islands?
Yes.
Under Delaware law, what relevance does the oral testimony of the grantor of a trust have to the construction of that trust?
The general rule applied by Delaware courts, primarily the Court of Chancery, is that the construction of a trust instrument is governed by the four corners of the instrument. And of course, the court can apply typical rules of construction, one being that words are given their common or ordinary meanings, and a second that the intent of the grantor is to be derived from all of the provisions of the trust agreement read as an entirety. And so grantor testimony would typically not be admissible to vary the terms of the trust instrument.
Under Delaware law, is control a legal concept or a question of fact?
I think it's primarily a question of fact. There is no, at least in the trust law context, I'm not aware of any set of rules or definition that says if these criteria are satisfied, then control exists and not otherwise. So it's looking at the cumulative facts.
Mr. Olson, I understand that you'd also like to summarize the contents of your report and respond to the comments of your colleague, Mr. Flubacher.
Yes.
Please proceed.
Thank you. Before turning to that, let me give a brief introduction. I'm a member of the Delaware Bar, was admitted in 1976, and have practiced in Delaware since that time. More recently, my practice has concentrated on estate planning matters and matters of federal taxation, primarily limited to wealth transfer taxes, which are gift, estate, generation skipping transfer tax. I'm a retired partner of the firm Morris James in Wilmington, and my current status is of counsel. To respond to your question,
Thank you, Mr. Olson. No further questions.
Mr. Pulesio.
Thank you. Can you hear me okay? Thanks. Mr. Olson, good morning. Good afternoon.
good afternoon.
I would like to start, if I may, with some statements at the beginning of your opinion. And I'm going to read the first of those statements. You said, Ernesto Palacio Hurtado is a resident, domiciliary, and citizen of Italy. You didn't have any basis for that statement, correct?
My basis for the statement was that it was represented to me, it was represented to me by counsel.
Counsel represented to you that Ernesto Palacio Hurtado is a resident of Italy?
Yes.
Who at counsel's table represented to you that?
My primary point of contact was with Mr. Boykin, so I assume that it was he.
Okay. Another statement in your report is, I'm going to read it. It says, Mr. Palacio has an affectionate family relationship with Carla Palacio and Valeria Palacio, who are the daughters of his late brother. Both Carla and Valeria are citizens of Italy living in the United States as permanent residents. The basis for that statement was also representations to you by Mr. Boinke?
That's correct.
At any point did you speak with Ernesto Palacio, Carla Palacio, or Valeria Palacio?
No,
Did you ask to speak to them?
no.
We are in agreement that these two trusts at issue here are Delaware law trusts.
Yes. By their terms, they provide that they're governed in accordance with Delaware law.
And what that means is that Delaware law governs the duties and activities of the trustee.
In general, it means three things. One is that the administration of the trust occurs according to Delaware law, so that's a more complete answer, I think, to your question. Secondly, it means that the terms of the trust are construed in accordance with Delaware law. And third, that in general, the situs of the trust will be Delaware. Delaware courts will have jurisdiction over enforcement.
Understood. I could put it simply, it means that the rights and obligations of all the parties related to the trust are governed by Delaware law.
By Delaware law and the terms of the trust instrument.
Correct. Not Italian, though.
No.
And am I also correct that the place of administration of these trusts is Delaware? Yes?
Commonwealth Trust Company is a Delaware corporate fiduciary. I happen to know that they have an office in Delaware. And the trust agreement goes to great lengths to make sure that the trust is administered from the state of Delaware. So, as far as I am aware, the trusts are administered in Delaware.
But I would go even further, Mr. Olson. I believe this is a legal matter. I'd refer you to Section 3340. Are you familiar with that section? It's your exhibit number 5, 3340. And I'm going to read where it says place.
Oh, yes.
Yes. So as a legal matter, the place of administration of these trusts is Delaware, yes?
Yes.
Not Italy?
I'm sorry?
Not Italy.
No, sir.
In your report, you discuss the issue of settlor intent, yes?
Yes.
And you discuss it in connection with the issues of whether there is a principal-agency relationship, and also in connection whether this is a will substitute. Is that fair?
Yes.
And you say that to determine settlor intent, you need not go further than the four corners of a trust document.
As a general rule, it would be true that a court would not go further than the four corners unless there were a material ambiguity which the court could not resolve through an examination of the trust instrument and the application of the rules of construction that I already mentioned.
Right. So, understanding what evidence would be admissible or not in a Delaware court proceeding, I understand the point that you've made, but separate from that, you didn't seek to speak to Ernesto Palacio to determine his intent.
No.
And you didn't seek to speak to Carla or Valeria to determine any intent that Ernesto Palacio may have had.
No.
So to analyze intent, all you did was read the trust agreements. Is that fair?
Read the trust agreements and apply my experience as a Delaware lawyer.
Right. 3313, right. And 3313 is a statute that created in Delaware this creature of directed trusts, yes?
I think it gave, I would say that it gave statutory approval to the creation of such trusts, which is not to say that they might not have existed before that. But the primary purpose of Section 3313, as I understand it, is not only to recognize the bifurcation of one set of duties, namely administrative, from a different set of duties, namely investment, but also to insulate a directed trustee from liability for simply following the directions that that directed trustee is given.
Right. So what 3313 did was codify trusts in which there is an advisor, individual, or entity providing direction to the trustee about what to do. In essence, is that correct?
That is one part of it, and the other is the exoneration of the advisor for acting in accordance with the directions the advisor is given.
Right. And these two trusts at issue here fall within what is defined as or known as a directed trust.
Yes.
Right. Are you aware of any case in Delaware that has ever held that in a directed trust, the relationship between trustee and grantor is that of a principal and agent?
No.
Claimant.
No questions?
Mr. Olson, thank you very much. No further questions from the tribunal either, so you're free to go. We thank you for your patience and presence.
Thank you, Mr. President and members of the tribunal.
Okay, we're going to take a 15-minute break, and then we will give some instructions to the parties and ask questions, a couple of questions that we have on the way to follow. So we'll see you in 15 minutes. Thank you. Okay, welcome back. We have some administrative issues on the path to be followed. First, the tribunal considers, unless the parties think that it is absolutely necessary, that we do not need post-hearing briefs. We have been briefed sufficiently with the documents, the experts, so I don't think we need that. That's I don't know if the parties would agree to that. And in lieu of the post-hearing briefs, we would like to receive a joint expert report from the experts on Cayman law. A joint expert report simply indicating briefly what are the points of agreement, what are the points of disagreement. Why is that? Because there was whatever the reason, but there was a disconnection between the documents that each one reviewed. So we want an opinion with reviewing the same documents, no additional evidence, no additional documents, only their expertise on Cayman law based on the documents that are related to the Cayman trusts. So that's a proposal that we have. But of course, as I said, if the parties consider that you need post-hearing briefs, of course, we're open to hear otherwise.
Mr. President, that's acceptable to claimant.
Likewise, Mr. President. Thank you.
Okay, so we will give some instructions to the parties on the joint expert report. That instruction may or may not include questions for the two experts. That would include also a page limit. We don't want long, never-ending expert reports, but it's again a report indicating what are the points of agreement and what are the key points of disagreement with respect to the documents related to that, the Cayman trusts. That's one thing. The second is how long do you need to review the transcripts and see if you have an agreement and submit to the tribunal any disagreements that you may have? Would a couple of weeks be sufficient?
2 weeks, 3 weeks, but 2 weeks should do it for a claim.
2 weeks would be okay with us.
Okay, great. And last but not least, submissions on costs. The preference of the tribunal would be not to have any additional pleadings on costs. You have already indicated in your pleadings what your view of that is. So what we would suggest is a statement of the different items of the costs certified by counsel as true and correct. And with no further pleadings. That would assist us a lot in I don't know, claimant, if that's acceptable.
That is acceptable, Mr. President.
Thank you. Respondent?
It is acceptable, Mr. President. Just one question with respect to the transcripts. We have 2 weeks, I suppose, from the final, when we receive the final version of
Yeah,
the
of course,
transcript. Yes, okay.
up to
Thank you.
when you receive the final version.
Understood, thank you.
Okay. So we will provide you with written instructions within the next very few days on this expert report. And how long, and that's something that you would have to consult with your experts, because we cannot fix a time. So what I would suggest is that you confer with your experts on how long would they take, their availability, and give us tomorrow or no later than Friday an estimate of how long would it take, so that we can issue the corresponding procedural order. So if let's say Friday, if you can confer with your experts and by Friday let us know how long would it take, so that will give you a reasonable amount of time. I don't know, Horacio, anything else? Brigitte? Anything further from claimant?
From our side, the only thing that remains is to thank the tribunal, the ICSID staff, court reporter, everybody who makes all the magic happen with the screens, our opposing counsel, and everybody here for the hard work that goes into this and the attention. And thank you, above all, for your careful attention.
Respondent, anything you would like to raise at this time?
just one question. The tribunal will, when issuing the decision, decide how to deal with the statements of Pelas and Palacio. Yes.
Yes, of course, we will, in our next procedural order, we will deal with the decision on that, of course.
Understood. Then nothing further from us other than to thank you, the members of the tribunal, the ICSID staff, opposing counsel, and everyone else. Thank you.
Okay, with that, we conclude. We thank the parties, counsel and the parties for your work, efficient, to the point, very helpful, and that's the reason, one of the reasons why we do not need the post-hearing briefs. And so thank you, and we also want to thank, we know there are a lot of juniors behind your teams that are not seen in the hearing, and we want to convey our thanks to them as well. And of course to our court reporters and the ICSI staff, to Gonzalo, and to my dear colleagues, Professor Stern and Professor Grijera. Thank you so much, and have a good rest of the week.